Hi, my name's David Richards. I'm a solicitor at Leeds Prior. I specialise in construction law. I'm doing a series of videos on myths and misconceptions in the construction industry and the legal rights and obligations that people have. This week I want to talk about the right of suspension. So that's the right to suspend work, to stop work temporarily until you get paid. Now it's common sense, it's logical, it makes sense. Surely if the builder, the contractor, isn't being paid, they ought to be able to stop work. No payee, no workee. Doesn't quite work like that in all situations though, particularly for residential projects. A bit different with commercial. So with commercial, and I'm talking about factories, shops, anything like that, offices, but also with a developer on a residential project. So essentially anything other than a residential occupier. If you fall within that quite broad category, which most projects in the UK, you've got rights under the Housing Grants Construction and Regeneration Act 1996. You've got the right to suspend work, but only if you follow a certain procedure. So, if your contract provides for the right to suspend, you have to follow that procedure, assuming it complies with the Act. Certainly JCT and NEC and those sorts of things have the right to suspend written in them. If you don't have that provision in your contract, then the Act fills in the gaps. So for non-payment, and when I say non-payment, it has to be non-payment after the final date for payment. So in construction you get this due date for payment, and then there's various payment notices procedures, and then you've got the final date for payment at the end. If you've not been paid after the final date for payment, you've got the right to suspend the work. But you have to serve a notice, and you have to serve a notice that gives at least 7 days, and it has to specify what the breach is within the notice. And if you don't do that, then you don't have the right to suspend, and the horrible consequences that I'll talk about in a moment. So if you serve that notice after you've not been paid after the final date for payment, you have the right to suspend your work until you've been paid. No workee, no payee. For residential projects, it's a little bit different. For residential projects, the Act doesn't apply. This is for residential occupiers. In those circumstances, if you suspend your work, if you say to the resident, I'm not going to work until I've been paid, what that amounts to in legal terms is what's called a repudiatory breach. And what that means is that you will have breached the contract in such a bad way that it will allow the resident to terminate the contract. Okay, so the resident will be entitled to say, okay, you're such a bad builder that it's over between us, and I'm entitled to sue you, the builder, for all of my losses. So that includes the cost of completing the project, or the increased cost of completing the project, and I'm not obliged to pay you any more for any right of payment that arises thereafter. I'm entitled to put an end to that. That's a problem when it comes to building projects, because in practice, after the resident has terminated for repudiatory breach, the resident will invariably try to make a claim against the builder for all of the cost of building, and the cost is always 10 times as much as the builder would have completed it for. So even despite the obligation to mitigate loss, it's always a lot higher, so it's a problem for builders. The better way to proceed for the builder, if it really is going to be a problem, what they need to do is to say to the resident, look, you have this obligation to pay, it's come up, and then you make time of the essence. So you say to the resident, look, if you don't pay my invoice by a particular date, within 14 days, I'm talking about money where the final date for payment has arisen, you've served an invoice, they haven't paid, you give them another 14 days and say, if you do not pay this invoice within 14 days, I, the builder, am going to terminate the contract, and in the meantime, I'm going to carry on working. I'm going to carry on accruing money for me, and then if accruing the right to payment to me, the builder, and if they don't pay the money after the 14 days, then you are likely to have the ability to terminate the contract. This is a very, very difficult area of law. If you're considering going down this route, you must take legal advice. A lot of the cases that I deal with on a day-to-day basis are about disputes between builders and the residents or commercial property owners arguing over who was in repudiatory breach. Was it the builder? Was it the property owner? Was it the contractor? Was it the subcontractor? And the reality is that in some cases it could go either way. There are some cases that have better prospects than others, but there's often a bit of a risk when it comes to repudiatory breach because all of the circumstances of the case are taken into account. It also makes it an expensive dispute because you've got to look at detailed factual provisions. The bottom line, though, is that if you're acting for a residential occupier and you're a builder who hasn't been paid, you are not automatically entitled to suspend your work unless it is written into the contract. So the best way of proceeding is to have it in your contract in the first place. So your contract, your terms and conditions, or your building contract with the residential occupier says that if you're not paid within a certain period of time, you have the right to suspend your work. That's the better way to set up the project in the first place. Failing that, do not suspend, seek legal advice and build towards termination if you need to, or find some other way of resolving it with the resident. And as I say, with commercial projects, a bit different. After the final date for payment, 7-day notice, you've then got the right to suspend or something else depending on what's in your contract. And that's it for now. So, like I say, my name's David Richards, solicitor at Leith Prior. Got any questions? Give me a call. Have a look at our website.